And those were circulated in the notice of the reminder notice of the meeting. First outstanding matter has to do with inclusion of failure to disclose identity in the schedule of offenses in the pre-charge regime. Having regard to the concerns raised and the fact that this is a statutory offense under the law reform zones of special operations, special security, and community development measures, I believe we can delete this offense from the schedule of offenses. It is a statutory offense which is treated in a particular way, and by virtue of the penalty prescribed, it is not a serious offense under the ZOZO law. So while identity is critical in the determination of criminal matters, referencing the offense created under the law reform matter appears inconsistent with the category of serious offenses in the schedule. And so I would...
Sorry, Minister, you want to be more specific as to Schedule 1, Part 2?
Right. Remember, the schedule is Part 2 is now Part 1.
Oh. Oh, yes, yes,
right.
And it's there under both, right?
So,
yes.
But it's the same schedule where it appears in the schedule. May I invite a response or comment from the technical team before I ask members of the committee?
Madam Chair, just requesting a clarification. Since it appears in both parts 1 and 2, is it deletion for both items where they appear?
Just a minute. Just a minute, Madam CPC. Ms. Wilkins?
Yes, Chair, I was going to say that we had no difficulty with understanding the rationale for its removal, and that would be item 16.
You have a difficulty?
No difficulty with its understand the rationale.
Yes.
For its removal. But
it appears
at 16.
Remind me, Madam CPC, the proposed change to the schedule would be to take out the headings under what now appears as Part 1 and the heading at what appears as Part 2, and the list of offenses in Part 2 would become Part 1.
Yes, Madam Chair,
right.
That's it. So the heading would just refer to a part.
Right,
part
and
1, Part 2.
Part 1 would apply to those offenses for which bail, the restriction of the grant of bail after conviction. Please just remind me of the reference in the bill to what would be the new Part 1 and the new Part 2.
What is being renumbered as Part 2 is referred to in what is Clause 5.1c of the revised version.
Just a minute. 5.1c. Okay, so that is
being renumbered as
bail after conviction.
Yes.
Right.
And what's being renumbered as Part 1 is referenced in the current Clause 5.1a of the revised bill.
And just remind me why the headings were being deleted. I know, among other things, is to prevent any confusion regarding the list of offenses in the part, but...
Yeah, yes, because although in the main these schedules were devised for the particular purpose to which the headings referred, they were then being referred to for other purposes in the bill. So the headings no longer serve the purpose for which they were intended. And because it's a multi-reference, multi-use schedule, then it makes sense to delete the heading.
And remind me how the list of offenses in respect of the restriction on bail after conviction relate to the existing list of offenses in the Bail Act. Ms. Wilkins, just pull up the act for me, and just remind me how the list here compares to the list there.
The list in the Bail Act would not have had the more recent
Offenses.
Such as the lot
The
of
anti-gang,
scam
right,
and the anti-gang.
right. So it's an updating. That's really what I wanted to verify.
Right, yes.
Right. All right. May I invite comments from members? There is no comment from members. Then we would resolve outstanding matter number 1 by deleting item 4 and item 16 from the second schedule.
For clarification, that's item 4.
It's the same offense, where the offense...
what is renumbered as part 1 and item 4 of what is renumbered as part 2.
So for even greater clarity, we're deleting the offense of failure to disclose identity under the Law Reform, Zones of Special Operations, Special Security and Community Development Measures Act, where the offense is referenced in the schedule, either in part 1, in both parts 1 and 2.
Chair, just another updating would have been the firearms, the new Firearms Act.
To be added to?
No, it's there. It's there. I'm saying that's
I see.
another thing that updated the list that's in the Act.
The anti-gang law, the lottery scamming law, and the new firearms law would have come after the existing Bail Act.
Correct.
Yes.
Correct.
All right, if there is no comment from members in respect of the resolution of outstanding item number 1, I will move to the second outstanding matter. Question was raised whether a time frame should be specified for an application for bail in the post-conviction regime. Having considered the discussion, the points of discussion, and looking at the existing law and also the exceptional circumstances that may obtain post-conviction. I believe I propose for the committee's consideration that we keep the framework that is in the existing law and specify no time frame within which an application for bail post-conviction can be made. So we keep it as is. No time is specified. No?
I'm not sure if it was done already, but then that would have meant an amendment to 51C. Because the chapeau has a time period. So to ensure that it does not apply in the case.
Yes. Yes. Okay. Madam CPC, please note consequential revision.
Madam Chair, we had already made that change because we had already...
That's what I thought. That's what I thought. Yes.
So it will be reflected in the further revised version.
That's what I thought, because I recall the time frame was taken out of the chapeau. It was added at A and added at the start of B.
That's correct.
That's what my notes reflect. Yes. All right. The third outstanding matter is whether the post-charge, the post-conviction regime should include an appeal against sentence and not just conviction. So the proposal was for words to the effect or any sentence imposed in respect of such conviction. Having regard to the submission made on this issue, I have no difficulty expanding to include sentence in respect of the conviction. I'd invite a comment from the technical team. I see you shaking your head, Ms. Wilkins.
Because I think we're dealing with a person who has been convicted, and that fact of that conviction or the decision to convict is not being challenged. If the issue is sentencing, I see no rationale for this individual to be making an appeal. Why would you be on bail? I don't know. It seems...
Mr. Foreman, you have a perspective?
I don't think it's inappropriate.
Yeah, so I was just trying to check if there might be... Oh, sorry. It's on... Yeah, I was trying to check myself to see if there are...
The submission primarily came from Mr. Jarrett.
Yeah.
His
yeah, I recall
presentation to the committee.
His argument was that there may be circumstances where the sentence is such that if the person is not granted bail, the person might, for example, serve out the entire sentence before the appeal against the sentence is considered. And if I recall correctly, you may have circumstances where it's obvious that some error was made below in the sentencing aspect of the case. But if the Court of Appeal can't come to it before the person serves the sentence, it would mean that the sentence is served prior to that consideration. Yeah. So I think I recall that being the rationale.
Right.
But then the very appeal may not be heard prior to the sentence period of sentence being. Yeah. So I'm not sure that is basic.
But you may have a case where on appeal the sentence may be suspended, for example. So it's not a case where, or it could be an offense that carries both fine and confine, a fine and confinement, and so it is within the discretion of the court. I mean, as a matter of principle, an appellate court does not interfere with the exercise of judicial discretion unless there was some error in law. Even if the court constituted would have made a different decision, that is not the basis on which judicial discretion is interfered with in law. Any comment from members of the committee on this matter? If you recall the deliberations and the submissions made.
No comments at this time, Chairman.
Thank you, Member Charles.
Good morning, Chairman.
Morning, Member Sinclair.
In respect, I don't have any opposition to the addition of the words or any sentence imposed in respect of such conviction. Because there can be an appeal, not against the conviction. You can have an appeal against the sentence imposed, and in fact there's an authority I came across relating to a sentence of imprisonment that was imposed on a person who had appealed it, and the Court of Appeal did remove the sentence of imprisonment and replaced it with a suspended sentence in the circumstance of that case. So one doesn't have to appeal against the conviction.
Did the case say to remove the imprisonment or that it suspended the service of time? Because if the sentence is one of imprisonment, it's one of imprisonment.
It was one where, because there was an option of imposing a fine. And in fact, under the Criminal Justice Reform Act, I mean, it speaks to the court looking first at other types of sentencing instead of imprisonment. Imprisonment comes as a last resort. So it could be in the circumstance of in regard to social inquiry report and other considerations that the determination of a term of imprisonment could be viewed as being incorrect in the circumstances. So as I said, I have no opposition to the words added or any sentence imposed, and that is based on, as I said, authority that
the rationale for
does exist.
Yes, the rationale for limiting the scheme to appeal against conviction remains a valid rationale.
Yes.
Because, however, I thought the submission made by Mr. Jarrett made sense. And having regard to the fact that even where a sentence of imprisonment is imposed, on appeal it is quite proper in an appropriate case not proper, it's possible that sentence could be suspended. So the convict would not be serving time. I really see no harm generally in...
And I agree with you on that, Madam Chair.
Yes. because we do now have appeal against sentence. So if there is any unlawfulness in the sentence, it's a matter that can be put before the court by the prosecution. All right. Any other comment from any other member? Ms. Wilkins, I'm seeing your face. Others are not. Is it a reflection of your discomfort?
I understand that a balancing act needs to be done.
Yes.
But I'm just, as I was sharing with my colleague, Mr. Foreman, the scenario of an individual not serving a day because they successfully obtained bail, and by the time the appeal was heard, the period of incarceration would have elapsed, and someone who are in those circumstances don't spend 1 minute in prison.
Well, it's not.
I'm not sure if the public interest has been served in such a situation.
But if the person is convicted, the person will have the conviction recorded against his or her name. Outside of fixed sentences, which the court would be obliged to hand down, really, if there is a menu of sentences to choose from, that ultimately is a matter for the court's discretion in the circumstances of each case.
But does the language have to be so open, or any sentence imposed?
Well, Madam CPC, we can take some guidance from you on that.
Well, it would depend on what is the policy. Is it then that it's what is considered restricting the appeals against sentence to cases where the sentence is maybe over a certain number of years? Because I think that's the only context that I can think of where the words could be further limited.
All right, I tell you what. Let me reserve this for further consideration. We'll come back to it, because each choice must have a proper rationale. All right, let's move to item number 4, outstanding item number 4, and this has to do with the committee's acceptance of the recommendation that an offense should be created for tampering with or destroying the electronic monitoring device where a defendant, where such a condition has been imposed on a defendant. And I think the issue was what penalty? And looking at what exists elsewhere and what an offense would be targeting, the penalty being proposed is fine and confine, $1 million or 1 year or both. You can find the appropriate words, Madam CPC. Let me just invite comments from members before we finalize.
Madam Chairman?
Yes, Member Bunting?
For the, I'm drawn to the reference to the Cayman Islands Act, and I think something along those lines would be appropriate. However, I'm not up to date on what an actual tracking device would, or monitoring device would cost, but $500 doesn't seem very high, relative to the infrastructure for those things. So I would
Right, and that's the adjustment we made within our scheme.
Yeah,
and that's where the $1 million or a year.
So in our scheme, then we would be talking
Yes.
$1 million. 500 Cayman would be 600 US. So that would only be,
Right.
$800,000. So which I thought was low. So I have no problem supporting the $1 million or 1 year imprisonment for tampering with attempting to destroy or manipulate the
Right.
monitoring device.
Thank you, Member Bunting. So for every recommendation that we accept or reject, and for every provision in the law, there is in fact a proper rationale. And in this case, we are guided by how we grade penalties on the monetary side and on the imprisonment side, and also having regard to a replacement cost and a deterrent element, because if a condition of the bail is that you be geofenced, monitored electronically, that goes a long way in relieving the prison population, the detention population, and to tamper with that can't be taken lightly. If persons are ordered to stay within a physical locale, I would imagine that there would be good reason for that based on the circumstances of the case. But thank you. 1 million and/or 1 year. Madam C.
And is that on summary conviction before?
Yes, summary conviction.
A parish court.
Yes. Although increasingly I wonder whether for ease, matters like these could be tried in the court where the major offense is being dealt with. So if part of our goal is to I leave it at that. Let me take back the thought I was expressing publicly on summary conviction. Ms. Wilkins, would it assist for some further time for the LRD to look at the recommendation in respect of the sentencing, adding sentencing to it? The CPC had indicated we could look at a more restricted policy consideration instead of carte blanche.
Mr. Foreman found a judgment that was very helpful, but Ms. Simon is looking to so we will provide you with some information. Another half an hour, whatever we find in another half an hour. Thank you.
All right. Could that half an hour be 10 minutes?
We will make it 10 minutes then, Chair.
All right. I believe we may need 2 or 3 other meetings to consider the revised draft, not at large, but just to provide an opportunity for all members to go through the revised draft, and then for us to consider the report of the committee to the House on this matter. Madam Clerk, you will need about 2 weeks to get the report ready and the minutes. All right. Shall we then look at some dates? So not next week, but 29th. Wednesday the 5th, I have constitutional reform, the CRC meeting on that day. Thursday the 6th? Okay. So we can do Thursday the 6th. We can do Thursday the 6th and we can do Tuesday the 11th.
Yes, no, we can't. There's
Okay.
a meeting here, confirmed, tobacco.
Okay.
Afternoon will be the sitting of the house. Perhaps you want to come here and look out? This is free. This is free here.
13th?
Yes.
6th and 13th. 6th and 13th. It's fine. So we do the 6th.
Sure.
The 6th is available.
Yes, in the afternoon though.
All right.
13th in the afternoon as
All
well.
right. And can we get one other full day? Wednesday the 19th. All right. Members, I am proposing for your consideration 3 remaining dates. 2 will be 2 half days, so in effect it would be really 2 full sittings. On July 6, because the other dates are taken by other committees. Thursday, July 6 at 2 p.m. Wednesday, July 19 at 10 a.m. Actually, Wednesday at 2, because I could still do...
I won't be able to do the July 19th. That I'm traveling that week, but you know, perhaps if there is a July 19th, the day July 19th is out for me. But if there is a Zoom options, I can do it in the week, but not July 19th.
Very well, noted. July 19 at 2 p.m. And then Thursday, we also had the 13th.
Yes,
13th, sorry. Thursday, July 6 at 2 p.m. Thursday, July 13 at 2 p.m. Thursday, July 13. And Wednesday, July 19. Let's keep it at 10.
at 10?
Yes. If there is any change for the afternoon, then I'll indicate in good time. And that should allow us enough time to conclude our deliberations in this committee on the bail bill and to report to the House on the week of July 23, report to the House on July 24, Tuesday, July 25. Yes. So just to go back over, we're setting our succeeding meetings for Thursday, the 6th of July at 2 p.m. Thursday, the 13th, (2 p.m.), and Wednesday the 19th at 10 a.m. with some possibility that we may sit in the afternoon instead of all day. But please reserve 10 a.m. at this time. Just to be clear, the date of July 19, there is some likelihood that we could sit at 2 instead of 10, but at this stage, I would ask members to reserve 10 a.m. For the day. And the goal is to report to the House on July 25. I'll ask members to avail themselves for the signing of the report in time for the tabling of the report on July 25, all things being equal. And I think that should give both the clerk and the CPC enough time to deal with the administrative matters. Madam Director, Legal Reform, ready for me? So at our next meeting, we will have 2 sets of minutes to review, but they would be circulated ahead of the meeting. May we now return to the issue of the extent to which we include an appeal against sentence in the post-conviction regime. If the LRD and the AGC need a little more time, you are ready? Sorry? Yes? That there is, yes, but we know that as a matter of law. There is no presumption, yes, we know that. Please speak in the mic so that others can hear. I'm sorry, the Director of Legal Reform was saying that the decision of the court spoke to no right to bail post-conviction. But we know that because that... Right. No, we're not creating a right at all. No. Which cases were you referring to, Ms. Wilkins? Please speak in the mic when you respond so others can hear. What is the name of the case and the citation?
Sorry, Chair, I was still going through it. It's Derek Hamilton and the Crown. And I don't know if he's a member of this committee, but one of our senators, well, yeah, one of our senators was the, represented the appellant.
How is that Derek spelled? Is it 2R?
The Derek?
Yes.
D-E-R-E-E-K. Very, very odd.
D-E-R-R?
No, D-E-R-E-E-K. Derek.
Oh, Derek.
Yes.
Derek Hamilton?
Hamilton and the Crown.
And what is the citation?
Well, this is using VLEX, so let me see. JM 2013, CA 72.
It doesn't have a reported case citation.
No, this is it.
Okay,
it's VLEX that we're using, and you know they
that's
get
fine.
they get
That's fine.
the
It's a
judgments.
2013 case.
Yes,
All
but the
right.
Court of Appeal judgments are on their website in order of year.
Understood.
So yes, it
All
should
right.
be fine.
And counsel in the matter was what? Senator Sinclair?
No, Floyd Green.
Oh. Oh, I thought you said a member of the committee. You
No,
mean
no,
a
a member
of the House.
of the yes,
House.
yes, but
I
not.
see.
I said, but even though he's
Right.
not a member of this committee, he argued on behalf of the appellant.
Right.
He succeeded as well. Scantlebury, the other one, Scantlebury was cited.
What's the ratio of the case?
And they're citing Section 13, which is of the existing law.
What is the ratio?
Let's see now.
What was held is what I'm asking.
Oh,
And on what facts?
the decision,
Yes.
bail was, hold on, it seems to have been granted. But it looked at in deciding whether or not the special circumstances that have to be shown. I think that was really where I wanted the point to go, that I don't know if the law should just leave it wide open like that.
Right.
Because there are sentences that involve a fine, there are sentences that involve incarceration.
All right.
I don't know if we just...
I'm not inclined to make policy decisions on the fly. Let me take some time to read the case and see.
So
because we know the general
prepare
principle
something.
is that there is no right to bail post-conviction. We know that as a principle within our jurisdiction.
All right, we'll let you have something
And
before the
elsewhere, yes.
end of the day.
All right, so we will reserve consideration of the extent to which we will allow a convict to apply for bail pending appeal of a sentence. Madam CPC, you would therefore do the draft with the square brackets for options for consideration.
Yes, noted, Chair.
Yes. All right. I think that would be the business of the committee for today, unless any member has any other business for
So, Madam
consideration.
Chairman.
Yes.
No,
Yes,
I
Member
was
Bunting.
making a motion for the adjournment.
Oh, I see. All right. There is no.
And to ensure that you realize that I'm still here.
Well, I get your drift now, Member Bunting. You will spend an hour or two with us. So no other business. And my closing remarks really are to thank everyone for showing up at today's meeting and to reiterate the dates of our next meetings. Thursday, July 6, 2023 at 2 p.m. Thursday, July 13, 2023 at 2 p.m. Wednesday, July 19, 2023, we reserve 10 a.m. There is some likelihood that we may, in fact, commence at 2. I cannot now say at this stage. But please reserve Wednesday, the 19th, for the day. And we're hoping to report to the House on Tuesday, July 25. Will someone move for the adjournment? That was you, Member Bunting.
So move.
I think Member Bunting moved already.
Yes.
I'll second it, Chairman.
All right, the meeting is adjourned at 11:33 a.m. Thank you all.
Jamaica's currency has a fresh new look. Introducing the new $50 note. The new $100 note. The new $500 note. The new $1,000 note. The new $2,000 note. The new $5,000 note. Jamaica's new banknotes, modern, more secure, and made to last.